Hi, this is Jessica. This is a bonus video. One of your classmates suggested I do something a little humorous or in the order of a war story because that's a little bit what's missing from a online class. So here we go. I got this article from Medallion Leland. Medallion, if I've spelled your name or pronounced your name wrong, please don't shoot me. Um, Go ahead and read this. So it's a pro se lawsuit. That means somebody is suing without a lawyer, and it's a convicted kidnapper in Kansas. So he's whiling away his jail time. He's actually sued his victims, saying they breached an oral agreement to hide him from police in exchange for an unspecified amount of money. So he's thinking, um, they were supposed to hide him from the police, and there was some money, but it didn't say how much. So he is actually seeking $235,000 from the Rowleys, who entertained him when he broke into their home a little while ago. He has sued. Actually, it's interesting. This is a counterclaim to their suit against him. Their suit against him was for trespass. Obviously, he came into their house without permission. Intrusion, which is similar to trespass. And infliction of emotional distress, which is harm that they cause him, that he caused them by coming into their house. And so he countersued. It looks like maybe that's how this came about, was a countersuit. Countersuits, in my experience, are pretty common. Basically, what their goal is to distract the judge and put the counterclaim in full light and get more attention than the actual lawsuit itself. In a contract case, whoever gets to court first is the plaintiff, and that plaintiff usually gets top billing as being the victim. So having a countersuit and have the defendant sue the plaintiff is an attempt to steal the limelight, essentially, and make up for the fact that the defendant didn't get to court first. So let's see what they say. The Rowleys say there's no agreement, which is, of course, the foundation of contract is an agreement. And even if they did accept the offer, it wasn't binding because of duress, which means there was no mental intent to form the actual agreement. He had a gun to them, after all. And illegality, which means the subject matter of the contract was illegal. You can't have a contract to agree to hide somebody from the police in exchange for a certain amount of money. They point out also there was no specified price, which means, gosh, how could we even have formed, the offer itself was ambiguous, assuming there was an offer. How could we have even agreed to that? Because it was so vague. I love this part about the Rowleys gaining Dimmock's trust by eating Cheetos and drinking Dr. Pepper with him while watching the movie Patch Adams. They managed to escape after he fell asleep, probably on the couch with his stinky feet up on the coffee table. In yet another example of an unworthy lawsuit, he filed a civil suit against the city of Topeka because the officer's gun accidentally discharged when they came in to get him. So this is basically a contract instructor's dream case because there are so many issues. Let's go through them. No meeting of the minds, no actual agreement. The concept of statute of frauds, which we haven't really talked about yet, but it means that there's no writing. In certain cases, a writing is required. Not all of them. There can be oral agreements, but the statute of frauds specifies that if you meet certain criteria, you must have a writing. Duress. We haven't gotten to that yet, but it's one of the elements of contract, and essentially, if somebody holds a gun to your head, you're not entering volitionally, of your own will into the contract, so there's no actual agreement. And illegality, of course, the very nature of the contract is illegal. So what should happen? Counterclaim dismissed. Maybe he had a lot of free time in prison and learned how to sue. And this just goes to show you that you can always sue somebody, but that doesn't mean you'll win. Until next time, Jessica.